Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Hello, everybody. Thank you for joining us for today's online talk on breach of contract, the COVID-19 aftermath. My name is Suan. I'm an associate with Mawing Kwai & Associate, and I will be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Mawing Kwai & Associate is a mid-sized law firm that was founded in 1985 by Datuk Mawing Kwai. Our able team today comprises of 23 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment department, and a department focused on servicing the needs of individuals and families. Our practice groups indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is the last talk in our MWK online talk series for 2020. But please feel free to visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks in 2021. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce both our speakers for today. Our first speaker for today is Ms. Denise Phang, a senior associate in our dispute resolution department. She holds a Bachelor of Law from University of London. Denise was admitted to the Malaysian Bar in 2015. Denise's primary area of practice includes corporate and commercial contracts, adjudication, arbitration, construction, and land acquisition matters. Next, we have Ms. Hannah Patrick. She is also a senior associate in our dispute resolution department. Hannah holds a Bachelor of Law from University of Malaya. She was admitted to the High Court of Malaya in 2013 and to the High Court of Sabah and Sarawak in 2017. Hannah's primary area of practice include general litigation, construction law, administration of estate, and debt recovery. All speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, please do not forget to post them up on Slido and our speaker will address them later. You should have received a link to Slido during registration, but I will leave this slide up for a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage and key in the code 30097. I repeat, 30097. Here are our top points for today. During this talk, Denise will start off by explaining what amounts to a contract. She will also give us a brief overview of the temporary measures of reducing the impact of coronavirus disease 2019 Act 2020, which is the COVID-19 Act. Next, Hannah will explain the relief and limitation of the Act. With that said, I will now invite Denise to share her insights. Over to you, Denise.
Thank you, Suen. Good afternoon, ladies and gentlemen. Thank you for joining us here at Mawingko and Associates. So without further ado, kindly just allow me to share my screen with you and we'll jump right into today's topic. Okay, as Suen has introduced, so there will be 3 talk points today. I'll be covering the first 2 talk points and a little bit about reliefs under the COVID Act. So moving on, contract law in Malaysia is governed by the Contracts Act 1950. A contract, as everybody would know, is a consensual agreement between parties. This is defined under Section 10 of the Contracts Act 1950. We will just pronounce as CA 1950 later on. So there are 5 basic elements of a contract. One is offer and acceptance. So for example, someone will offer work scope of a job scope, and then there will also be party B who accepts the offer. Party B can also make a counter offer, and which can then later on be accepted by party A. So there is an offer and acceptance negotiations ongoing between 2 parties or more. So basically, once offer and there's a definite offer and complete acceptance of the terms, so that then the contract will more or less be in form. Next, there is also consideration. Consideration, normally we'll talk about price consideration. This will be normally the contract sum. For example, if let's say the contract is for provision of services, so then the consideration would be the contract price of, for example, 5,000 ringgit. Okay. Intention to create legal relationship. So basically, this is normally shown by putting the contract in writing and for parties to both sign the contract. Then we have certainty as well. So this can also be evidenced by a written contract. And legal, last but not least, legal capacity. So in Malaysia, the age of majority is 18 years old. So you would need to be at least 18 years old in order to enter into a legal and binding contract. Okay, like I mentioned before, contracts can be in oral or in writing. Though nowadays it's very prudent, we do advise clients to put the terms of the contract in writing. There are sometimes parties may neglect to sign the agreement. So sometimes there can be a contract by way of an oral agreement or by conduct as well. So the second feature of a contract is that it should be clear, specific, and unambiguous. Like I mentioned, the terms of the job scope, the price, the contract price, and everything needs to be clear. And last but not least, the last feature of a contract, in the object of the contract must not be illegal, in the sense that the object matter or the subject matter of the contract must be legal. For example, if a drug dealer were to enter into a contract, he can't later sue for a breach of contract because dealing with drugs in Malaysia is illegal. So hence the court would not uphold such a contract. In fact, the drug dealer would definitely be arrested under the Penal Code or Dangerous Drugs Act in Malaysia. Okay, moving on. So a breach of contract is provided under Section 74 of the CA 1950. Essentially what it is a broken contract, in the sense that parties have broken their promises to each other and have failed to discharge their obligations under the terms of the contract. So what happens if one party can't fulfill their obligation under the contract? So the party who suffers by the breach, we do call it a breach of contract if you can't fulfill your contract, is entitled to receive from the party who has broken the contract compensation for any loss or damage caused. Okay, so this compensation must not be too remote. There must be loss or damage caused. So if, for example, even if one party does breach the contract, but the other party does not suffer any loss, so there can't be any claim for compensation. And for example, I'll give you a very brief example. Let's see. If, let's say, I contract somebody to do cleaning services, and that person is 500 per hour, and if, let's say, that person can't do it, then I contract somebody else to do it, to offer the cleaning services at, let's say, even a much lower price of 450. So I can't then later on bring an action against the original contractor for loss of 500 ringgit because, well, there's no loss and damages. In fact, there is an advantage gain because you did manage to save 50 ringgit from engaging the subsequent contractor at 450 ringgit. So that is a classic case. So then if, let's say, I'll give you a second scenario. If, let's say, the second cleaning contractor that you've engaged had to do it at, let's say, due to the emergency or last minute engagement, he quoted a price of 700 ringgit. So then you would be entitled to claim against the original first contractor, the additional 200 ringgit that you had to pay the second contractor, in the sense that because you failed to discharge your obligations of offering cleaning services for 500 ringgit, I have now incurred a further loss of 200 ringgit. Okay, so that would be your claim against the original cleaning services service provider. Okay, now we're moving on to an overview of the COVID Act 2020. So this act is actually called, the official name is called Temporary Measures for Reducing the Impact of Coronavirus Disease 2019, bracket COVID-19 Act 2020. So that's a very long name. So in short, we'll just refer to it as the COVID Act. Okay, it was published in the Gazette, in the Federal Gazette, on the 23rd of October 2020. So it was quite recent. And it has a total of 19 parts. It has been subdivided into 19 parts. For the purposes of this talk, we will be only emphasizing on 2 parts. And the date of commencement and period of operation would depend on each respective part in the Act. So different parts of the Act will have different periods of operation and when it starts to commence. So, but in general, it's in operation for a period of 2 years from the date of publication, which is again 23rd October 2020. Now, this period of 2 years can be extended by the Prime Minister under the COVID Act. So like I mentioned, we'll be focusing on just 2 parts. There are 19 parts, so it's rather impossible for us to cover the entire Act today. But these 2 parts are the most popular in the sense for our clients. So part 2, inability to perform contractual obligations, and part will be covered by myself, me. And part 11 will be covered by Hannah later, modifications to the Housing Development Control and Licensing Act 1996. Okay, right off the bat, we have Section 7 of the COVID Act. So Section 7 provides that for the inability to perform contractual obligations. So if I may just read, everybody can just refer to the screen. The inability of any party or parties to perform any contractual obligation arising from any of the categories of contracts specified in the schedule to this part due to the measures prescribed, made, or taken under the Prevention and Control of Infectious Diseases Act 1988, Act 342, to control or prevent the spread of COVID-19 shall not give rise to the other party or parties exercising his or their rights under the contract. Okay, so there are two main points that you need to emphasize in this Section 7. One, there are two conditions. What I would say is main condition, okay? So one, your contract must be specified in the schedule in order for Section 7 to apply. If your contract does not fall under the schedule, then I'm sorry, the Section 7 of the COVID Act does not apply to your contract, okay? Number two is that the failure to perform your contractual obligation must be due to the measures prescribed, made, taken under the Prevention and Control of Infectious Diseases Act 1988. So your failure to perform your contract must be due to something, a measure under this Prevention and Control of Infectious Diseases Act. So maybe I'll just refer to it as PCID Act, okay, the PCID Act. So moving on, so what contracts fall under the schedule of Section 7? There are a total of 7 types of contract. Okay, the first one would be construction work contract. So basically, contracts between contractors, subcontractors, and normally consultancy contracts as well, professionals, for example, architectural or engineering contracts, and any other contract related to the supply of construction material, equipment, or workers in connection with the construction contract. So basically, one of the industry most hit by the COVID-19 or the MCO under the PCID Act was the construction industry. So one of the main contracts now covered under the schedule would be construction contracts. Second, performance bonds or equivalent that is granted pursuant to a construction contract or supply contract. So again, this one ties in with the construction contracts. Third, professional services contract. Again, this clause can be quite wide. It's not limited to construction contracts, but it can be interpreted for other professions as well. But again, most professional services contract is usually related to the construction industry. Okay, the next 4 contracts that we have under the schedule would be lease or tenancy of non-residential immovable property. So what does this mean? I'll give you an example. For example, a tenancy of a non-residential immovable property would be a tenancy for a lot in a shopping mall. Okay, so it's non-residential because it's commercial, it's in the mall, and immovable property means that it's a unit or land. It's not as opposed to movable property, which is rental of a car and etc. Okay, so for example, rental of commercial property would fall under this provision. The next type of contract under Section 7 would be event contracts. So for the provision of any venue, accommodation, transport, entertainment, catering, everything, such event contracts are totally that can't be performed during the MCOs. So these type of contract is covered by Section 7. So if you're unable to perform such contracts, then parties would not be able to strictly enforce their contractual rights. Next, contract by a tourism enterprise as defined under the Tourism Industry Act 1992 and a contract for the promotion of tourism in Malaysia. Another industry greatly hit by the COVID-19 is also the tourism industry, so that this provision will be catered for that. And the third one will be religious pilgrimage related contracts. Okay, so one of the examples that I will show you would be, if you remember one of the preconditions, it must be a measure taken under the PCID Act. Okay, so one of the measures imposed under the PCID Act would be the prevention and control of infectious disease measures within the Infected Local Area Regulation 2020. So there will be a PCID Regulation 2020. This regulation is actually the main regulation why we have restriction of movement, or we say control of movement. So it was issued by the Minister of Health, published in the Gazette on 18 March 2020. So if you remember this date, this is the date where MCO started, okay? And it was enforced from 18th March to 31st March. So this was the first 2 weeks of the, what we call the lockdown or the MCO in Malaysia. So Regulation 3 sets out the control of movements and gatherings, prohibitions, and Regulation 5 actually says that only essential services will be allowed. Non-essential services are not allowed to be carried out. So in order for you to come under, to argue that to be exact, or to come under Section 7 of the COVID Act, number one, your breach or your inability to perform your obligation must arise from the PCID, a measure under the PCID Act or regulations. So the regulation is actually a subsidiary from the Act itself, a subsidiary legislation. That's what we call it. Okay. So another example would be the PCID number 2. I'll just call it PCID Regulation number 2. So then this was published on the 31st of March 2020. And basically was published to extend the control of movement order, and also and there are a few additional regulations. For example, Regulation 8, which restricts or allows movement to carry out works on infrastructure. So it allows works on infrastructure to be carried out for essential services. So basically, this would allow certain deliveries or movement of transportation. When we say infrastructure here, we mean transportation or services to continue. And these infrastructure services normally do only cater for the essential services. So there are many others, like for example, there are more than over 20 measures that was issued under the PCID Act. So in order to, for Section 7 to apply, one of it must apply to your specific contract, okay? So that is the end of Section 7. We move on to one of the other reliefs, and popular reliefs under the COVID Act, which is Section 9, mediation. So if, for those who do not know, mediation is actually a way of where both parties negotiate and come to a settlement on how to proceed with their contract despite any breaches. So the Malaysian authorities have actually set up this Pusat Mediasi COVID-19. It's under the Prime Minister's Department. You can actually access their website, pmc19.gov.my, and register for this mediation. So, but one thing to note is that this mediation is actually voluntary and not compulsory, and it's for disputes valued at 300,000 and below. Full subsidies is actually provided for the B40 and M40 categories, as well as micro and small industries. One of the advantages of going for mediation is that, lawyers are not required, though you can request for legal services of a lawyer, but generally lawyers are not required. Both parties can preserve their contractual relationship. Sometimes you just don't want to, sometimes because litigation can be quite hostile. And if you would like to preserve the relationship between both parties, then mediation would be a good option. So we would, this is one of the measures taken by the government. But again, it's not compulsory, and both parties mediation would require the consent of both parties. Then moving on, I think at this point, I'll pass the screen over to my colleague, Hannah, and she will run you guys through the rest part 11 of the COVID Act.
Thank you, Denise, for taking us through part 2. I will now take you through part 11. After that, we will take questions and answers. And I believe there are a lot of questions coming our way regarding this act. Part 11 is the part on modifications to the Housing Development Control and Licensing Act 1966. It covers section 32 to 38 of the COVID Act. Section 32 states that these modifications are deemed to have come into operation on the 18th of March 2020. So although this act was only gazetted on 23rd of October 2020, the provisions and the modifications to this HDA, Housing Development Act, I will call it HDA from now onwards to just make it easier. So the modification to HDA would have come into operation starting from 18th of March 2020. The modifications will affect SPAs entered into before 18th of March 2020. So for this part, any SPA, sales and purchase agreements that are entered before 18th of March, after 18th of March does not apply. And here, in this part, agreement means agreement for the contract of sale for the sales and purchase of housing accommodations in the form prescribed in Schedules G, H, I of the Housing Development Control and Licensing Regulations 1989, entered before 18th of March. We've got questions that ask if this applies to subsales. The answer is that this COVID Act is silent on subsales. So I will say that this part only covers the relationship, or rather the SPA, between a developer and a purchaser. Section 34 covers late payment charges. Subsection 1 is regarding developer to not impose late payment charges. If I may just read this. Notwithstanding any agreement entered into between the purchaser and the developer, where due to the measures prescribed, also taken under PICD, to control or prevent the spread of COVID-19, from 18th of March to 31st August, the developer shall not impose any late payment charges in respect of installment on the purchaser. And if the purchaser requires more time beyond 31st of August, if he still cannot pay, he can ask for an extension of time by applying to the minister to have it extended to 31st of December. We will now go to the delivery of vacant possession and liquidated damages. Under this section, March 18 to the 31st of August is also a period excluded from the calculation of the delivery of VP and liquidated damages. Again, the developer, if it requires more time to deliver the VP, can ask for an extension of time until the 31st of December 2020. So what this means is that the period from 18th of March to 31st August is automatic. It's automatic, and so developer do not have to apply for this EOT. We're off that position because the reading is very clear from that. However, if you want to extend it beyond 31st of August up until 31st of December, then you will have to ask for permission from the minister, the housing minister. Subsection 4 of section 35 is actually in relation to the deeming provision in standard clauses in SPAs. Standard clauses in SPAs say very clearly that 14 days, a purchaser has 14 days to take possession of the house. They are deemed to take possession 14 days after notice is given. However, if you are unable, you as a purchaser is unable to occupy the housing accommodation from the 31st of March to the 18th March to the 31st of August, you shall not be deemed to have taken such vacant possession. So what that means is that that deeming provision in your standard clause is lifted. The period is lifted. The 14 days is lifted. I would like to now give you an example of Section 35 on how it applies to a VP situation, delivery of VP situation, because right now there are no cases in court to tell us how it should be calculated. So this is how we interpret it, yeah? So to calculate the new date of VP, you have to exclude the period from 18th of March 2020 to 31st August 2020. Now that is 166 days. So for example, if the date to deliver vacant possession according to the SPA is on the 29th of August 2020, that's just right before the expiry of the exclusion period. There are two methods of calculation. Either, number one, you calculate the number of days from the 18th of March to the 29th of August. And in this case, it is 164 days. And you add that period, that 164 days, you add it from 1st of September 2020. Why 1st September? Because that is right after the excluded period of 31st August. And you will get the date 12 February 2020. The other method of calculation is that you add the entire 166 days starting from 30th of August. 30th of August is the day after the date to deliver VP. That's how we usually start your calculation. You add on 166 days from 30th of August, you also get 12th of February 2021. So either way, as long as you achieve a new VP date, it's good enough. But we hope to see in the future the court to be able to define how exactly is this time supposed to be calculated. Now for time that is after 31st of August, it's pretty easy. You just add 166 days to the VP date because you have to exclude that date. That's the logic behind this exclusion period. Defect liability period, notwithstanding any agreement entered into between the purchaser and developer, the period from 18th of March to 31st August shall also be excluded from the calculation of defect liability period, as well as time to make good any defects. This applies to the developer as well. This is the limitations that is imposed by the law on the application of this part to the HDA. Now, if you have already started any action to claim anything from the developer, or if the developer has claimed anything, you have already paid LAD to your purchaser, all amounts that have been paid cannot be refunded. That's one. And if you have already taken any action to enforce whatever it is that is in your SPA, these legal actions would be considered valid, notwithstanding the act. Right, I think that's pretty much it. I will now go to the questions. Sued?
Thank you, Denise and Hannah, for your insightful sharing. We will now take questions that some of you have posted on Slido. Remember, you can ask us questions on Slido, either by scanning this QR code on your left, or by going to Slido's webpage and keying in the code 30097. Now, we have quite a few questions today. As such, we will be limiting our Q&A session to the popular questions concerning today's talk. Okay, the first question for today. Will the COVID-19 Act apply to questions which were entered before the MCO? Hannah, Can you please take this question?
Okay, I think this one, because the COVID Act applies for different period of time for different parts. So it depends on what part. So for, if you remember my slide earlier about the contracts that, or the SPAs which are affected, they are only those which were entered before the 18th of March. So the COVID Act does apply to contract before the first MCO for HDA. And I believe different acts will, different parts will have a different timeline. Denise, do you have any insight on Section 7 maybe? Let us see. Section 7 says this part is,
Section 7 is from 18th March 2020 up to 31st December 2020. It does not actually restrict, the Act doesn't really say whether or not it applies to contracts entered before or after MCO, but reasonably we would assume that it's before MCO, and it doesn't put a, so basically it doesn't restrict the date you entered. So when we talk about contracts entered into before MCO, we are talking about the date of signing of the contract itself. It doesn't really impose a restriction on when you sign, but as long as the performance of your contract was affected by during this period, then I think you would fall under the Act, but provided again that your contract, for example, for Section 7, it must come under the schedule of Section 7, which there are only seven types of contracts. So yeah, I think that pretty much answers the question.
Yeah, so for this question, the answer is it depends on what contract you're looking at.
Okay. So then as a continuation to that question, so that would mean that even though parties didn't mention the COVID-19 Act, parties would be able to rely on the Act?
Does the contract between parties have to mention
the
COVID Act for parties? It's not, the question is not very clear, but if you are saying that if your contract does not mention COVID Act, then can we rely on the COVID Act? I think that's what the question is saying. The answer is no, you don't have to mention COVID Act in your contract, because naturally for contracts that were before MCO, it wouldn't have mentioned COVID Act anyway, right? So it does not have to mention COVID Act. It applies to you as a right. So different, like again, different contract will have different rights that are taken or given. Different periods are excluded. So so that's my answer for this.
Yeah, my short answer would be no, it does not need to mention the COVID Act.
Okay, thank you, Denise and Hannah. Moving on. In the sale and purchase agreement, especially in sub-sale cases, what are the terms and agreements that have been affected during this COVID-19 pandemic?
I'll take this case because sub-sale. Like I said earlier, SPAs which are not with developers, so if it's between owner to owner, I don't see it being provided in the HDA. So the COVID Act. The COVID Act is silent on it. So the most I can give an allowance for is the tenancy agreement, which was lease or tenancy of non-residential immovable property. So it's very specific to that kind outside of the SPA. So unfortunately, there is no provision for sub-sale cases.
Yeah,
at the moment.
Yes, the schedule to Section 7 doesn't expressly say sale and purchase agreement. So there is no such agreement under the schedule. And so arguably, it's not covered under Section 7 of the COVID Act.
Yeah, let's take this question. The question 1A, the contractor is requesting for a deferment or suspension of LAD using the COVID-19 Act recently passed by the government. Do they have a reasonable chance to succeed in court if the contractor is invoking this new COVID-19 Act against their client? What do you think, Denise?
Okay, suspension of LE. Again, the question is actually not clear on what type of contract is this. Yeah, so, but if we are talking about construction contract, then that will come under the schedule of Section 7. Okay, and then deferment and suspension of LD from when to when. If it does come under the period of the period in force, okay, where the Section 7 is in force, that will be again 18th of March up to December, 31st of December 2020. Then yes, maybe then the contractor would be able to rely on the COVID Act to for a suspension of LAD. Okay, but then if let's say this is not a contract under the schedule of Section 7, then no, the contractor can't rely on the COVID Act. So this question needs a little bit more detail, but I think I've covered two possible scenarios.
Maybe just to add to Denise's answer, if we're talking about construction contracts, and if it's going to involve extensions of time, if you want to know if you have a reasonable chance to succeed in court, the more evidence you have, the better. So the more documentations that you have to show that you are severely affected by the MCO, for example, between a certain period of time, that you were not able to move at all. Therefore, you need the extension of time. If you have evidence to show the court that you were affected during this period of time, you have a reasonable chance. So it really depends on your evidence as well.
Okay, since we can't continue our construction project due to the shortage of workers caused by the COVID-19, can we get an EOT based on the COVID-19 Act? Denise, what do you think?
Okay, again, so this is a construction contract under Section 7. Shortage of workers, but you must remember that the other precondition under Section 7 is that it must be under the PCID Act, a measure. You can't proceed with works because of a measure taken under the PCID Act. So shortage of workers. So I think the construction industry, the government did allow the construction industry to start work, I think fairly after quite some time after the initial lockdown start commencing on 18th of March, if I remember correctly. Yeah. So when you're talking about, and the government did allow workers with especially working permits to continue working. So then you would have to argue, or there are arguments on both sides. When you say shortage of workers, is it because of the measures imposed by the government under the PCID Act, or whether or not it's your own inability to procure workers during that period? Okay. For example, another example would be a measure taken under the PCID Act would be, for example, your workers are all under quarantine. So maybe then you can argue you are facing shortage of workers because of a measure under, because they're under quarantine, which is required under PCID Act. So therefore, you would then qualify for the protection under the COVID Act. But then again, there are various scenarios and arguments for and against. So it would depend on what reason, and is your reason under provided for or caused by the PCID Act. So then it would determine whether or not you can succeed or relying on the COVID Act. And Hannah, do you have anything to add?
No, I think you covered everything. Thanks, Denise.
All right. Our next question: is a contractor allowed to claim for EOT during the CMCO period if they have closed their site beyond what was allowed during the period? The last question.
Hang on, let me just read this again.
So I think they're asking if, so there's a certain period where construction projects are not allowed to proceed. So are they allowed to claim for EOT for that period?
I think Denise have answered it quite clearly. if you can show the court or show, for example, if you're applying for EOT and you're showing your principal or your main con that due to a measure taken by the government under PICD, you cannot go into the site. So you cannot just say, oh, because of MCO, oh, because of COVID-19, I cannot enter site. It has to be a measure that is officially taken under the PICD, right? So if if there are any other self-imposed restrictions which were not restricted by the government, you cannot use that as an excuse, arguably. Okay, so you will have to make a distinction there.
Okay. Moving on. There seems to be some problem with the Slido, so I'll just be reading out the questions. Okay.
Sure.
Okay. Based on the talk delivered, the remedy is mostly on compensation. So is there any other remedy available for parties like termination? What are your thoughts? Maybe Denise, you can take this first.
Termination. Well, it's not covered under the COVID Act. Sorry, I would need some time thinking about it. I don't think so. So if you did terminate in the circumstances, then if let's say the other party would say would say that you unlawful, the termination is unlawful, that they couldn't perform the contract due to the measures taken under the Act. Okay. So inability to perform. So Section 7, when you look at the wording of Section 7, if I can just refer to Section 7. The inability of any party to perform any contractual obligation arising from due to the measures under the PICD Act shall not give rise to the other party or parties exercising his or their rights under the contract. So normally the right to terminate, it's actually a right under the contract. Okay. So then I need to correct myself. Section 7 would apply in the sense that it cannot terminate you under Section 7. So because if you are unable to perform your contractual obligation due to measures under the PICD, then the other party, so the wording of Section 7 says cannot exercise his or their rights under the contract. That would include exercising the right to terminate you. So hence, they can't terminate you. And if they do terminate you, then there would be grounds to argue for unlawful termination. I think that would be the answer. Hannah, do you have anything to add?
That's correct. So basically what Section 7 says that if you have a right to do something, so termination is usually something given, a right given under the contract. If you are the innocent party, you cannot exercise that right according to the COVID Act.
But again, your contract needs to come under the schedule. There are just 7 types of contracts under the schedule.
Correct. It has to be limited within that categories.
Let's answer this. What if the CMCO is extended beyond 31st December? Is Section 7 still applicable? Then pending extension of minister? I believe Section 7 is under Denise.
Okay. What if CMCO is extended beyond? Okay, so Section 7, no. Short answer, no. Section 7 would not be applicable unless extended by the Prime Minister. Okay, so even if CMCO is extended beyond 31st December, which, okay, if let's say it's a high possibility, I would say, if CMCO is extended, then maybe the COVID Act might be extended, but it's not granted. Okay, the Prime Minister will still have to extend it and publish that in the Gazette. So without the official extension by the Prime Minister, then no, the COVID Act would not be extended beyond the date I think this question is specific to Section 7. So for Section 7, it will be 31st December 2020. So no, it would not extend beyond that.
Okay, moving on to the next question. Does the Act automatically grant an EOT to address delay that arose during the period between 18 March to 31st December for construction contract. Hannah, perhaps you can take this.
I would argue that yes, it does give you an extension of time, but in abundance of caution, I would advise any application for EOT to still be put in. So your notices must be there, your application has to be there. You cannot just assume that it applies, even though we do think that it's an automatic grant of EOT.
Okay, our last question for today. The inability to perform the contract, does it include inability to pay rental? What legal action can landlord undertake if amount owing adds up to more than 500,000?
What legal action can landlord undertake? So first of all, your tenancy agreement has to fall within the category. So if your category is lease or tenancy of non-residential immovable property, then you can enforce Section 7 in your contract. So that means, yes, you can take a legal action, file your claim in court and whatnot. Yes.
All right.
Does that answer the question?
Yeah, I think that answers
Anything to add? Anything to add?
So I think for clarity, for example, because this question doesn't say whether or not it's a residential or non-residential. For example, if it's, let's say, a residential property, so then it does not fall under the COVID Act. Okay, so then you still have, yes, then your tenants should still pay rental. And if, let's say, your rental is more than 500,000 outstanding, then by all means you can proceed to court or to claim for your tenancy or for your outstanding rental. But if, let's say, looking at the amount, if it's more than 500,000, I think this is most likely a commercial property. Then if it is a commercial property, then you would not be able to enforce your right under the contract. That's what Section 7 says, which means that you will not be able to recover your rent. Then again, that period of
exclusion.
Yes, 18 March right up to 12 December 2020. Yeah.
Okay, before we end, I believe we are ending, but let me just clarify on the EOT application. Now, you may have a ground to apply for EOT due to the COVID Act, but your contract, if it says you have to put in your EOT application, and if your contract has a lot of conditions to put in your EOT, you still have to fulfill that part of your contract. So it does not mean that you are given a free pass. I would like to emphasize that you do not have a free pass just because of measures taken under PICD, that you don't have to apply for EOT. All right. If you require a more detailed talk about construction contract with regards to this COVID Act, perhaps we can cover it in a later talk, because I believe we are running out of time. But this is something we see a lot of questions on, and we'll probably address it on another day.
We have 2 more questions that just came in. Perhaps we'll just end it after these 2 then. Can a contractor determine the contract if the client fails to honor progress payment during the relief period? Denise, what do you think?
So again, this question doesn't say what contract it is, but let's say it's a construction contract which falls under Section 7. And so similar to my answer earlier, if it falls under if it's a contract under the schedule of Section 7, and it is because of a measure under PICD Act, then you cannot determine, as in cannot terminate the contract. Oh, so this is a failure to honor progress. Yes, so you cannot enforce your rights under the contract. So your right under the contract will be for payment, progress payment. But then, but since the conditions of Section 7 has been met, you cannot enforce your rights during this period. So that unfortunately, that is the situation we are in. Do you have anything to add, Hannah?
No.
All right. Our last question for today. Is COVID-19 Act applicable to civil suits for those breach of contract due to MCO and COVID-19, and those comments before the 23rd of October 2020.
For SPAs, the saving provision says that no, it does not apply. Let me see for part 2. Give me a moment, yeah?
I think this is under section 10.
Yes, correct. Section 10, notwithstanding the legal proceedings. Yeah, it's the same. It's the same for part 2 and part 11. So if you have started your action before the publication of the act, unfortunately, it's deemed to be valid. That means the act doesn't apply.
All right, and that's the end for our Q&A session for today. Thank you, Denise and Hannah, for sharing your insights with us. Hold on, let me pull up the screen.
Most welcome. I hope you all find it useful.
Thank you for spending your afternoon with us.
So, before we conclude, I have a few announcements to make. First, please join us for our upcoming talks. On 13th of January 2021, our partner, Ms. Christine To, will speak on retention sum and late deliveries, rights and remedies. Next, please fill in our feedback form and tell us what you thought of our talks. The link to the form will be posted in the chat. Thirdly, please do follow or like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone and over video conference. Please fill in the form on our website. The link is also posted in the chat. Okay, thank you, everybody. Thank you for joining us for our last talk for the year. We hope to see you next year. I hope that you found today's session informative and useful. Stay safe and practice physical distancing and have a great day, everyone.